Well, good afternoon. Welcome to AEI and to a discussion of our new book, The Administrative State Before the Supreme Court, Perspectives on the Non-Delegation Doctrine. I'm Peter Wallison, a Senior Fellow Emeritus here at AEI, and also with me is John Yoo, non-resident fellow here at AEI and a professor at Berkeley, professor of law at Berkeley. John and I were the editors of this book. In the book, 12 constitutional scholars and lawyers discuss how the non-delegation doctrine might be revitalized and invoked by the Supreme Court and what effect that might have on both our jurisdiction and our jurisprudence and public policy. 7 of those scholars are here with us today and will discuss the paper discuss their own papers in 2 different panels. I will moderate the first panel and John Lee the second. Before we turn to that, however, I'd like to point out something highly unusual that has not received as much attention in the media as you'd think it might, even with the small sector of the media that covers the Supreme Court. This term, the court has also accepted 2 cases, one on the scope of the Chevron case and another that involves the non-delegation doctrine. This is significant because both, if decided in the wrong way from the standpoint of administrative agencies, could seriously diminish their power and activities. The interesting question is whether the court took these cases, both cases, for exactly this reason, and we won't know until the end of the term. Chevron, just to review that, was decided in 1984 in a case called Chevron versus Natural Resources Defense Council. There, a unanimous Supreme Court held that lower federal courts, when confronted with an ambiguous statute, could defer to the view of the agency about the scope of its authority, if the agency's view is reasonable. This has proved to be a boon to the growth of administrative agencies because lower federal courts have found it easier to approve the agency's claim of authority than to risk being reversed by a higher court. But there are indications that Chevron might be challenged in today's court. In 2013, in the case called City of Arlington, the court seemed to step back a bit from its support of Chevron. Chief Justice Roberts, dissenting from a majority opinion by Justice Scalia, who incidentally was one of the major supporters of Chevron, said, and this is quoting Roberts, "We do not leave it to the agency to decide when it is in charge." The following year, Scalia himself seemed to realize that Chevron had gone too far, noting in a decision that the 1946 Administrative Procedure Act makes it very clear that the reviewing court is to interpret the scope of an agency's authority. Oddly, Scalia described this as kind of an oversight, as though the court had gone on since 1984, creating one of the most important decisions they've ever made, without realizing that Chevron was inconsistent with the APA. This year, the court accepted and heard American Hospital Association versus Becerra, another Chevron case. The issue here is whether Health and Human Services has the authority under Medicare to alter the reimbursement rates that hospitals receive from outpatient drugs. The applicable law specifies 2 reimbursement methods: hospital acquisition costs and average drug prices. But HHS claims that it has authority also to adjust reimbursement rates as necessary, despite the language of the statute. The district court agreed with the American Hospital Association, but the Court of Appeals for the D.C. Circuit reversed, holding that the lower court reversed the lower court, holding that HHS was entitled to deference under Chevron, and that would allow it to vary the reimbursement for hospitals. If the court limits Chevron or questions its current or future applicability, it will be a major blow to the power of administrative agencies. The other case, and the one that we've focused on in the book, deals with the question of the non-delegation doctrine in a case that the court will hear later this month, West Virginia versus EPA. That isn't the only issue that the court could use to decide this case. But West Virginia and the appellants have argued that the EPA's application of its statutory authority violates the non-delegation doctrine, which holds that Congress may not delegate its legislative powers to another branch. Although many constitutional scholars and lawyers see it as protecting the constitutional separation of powers, it has not been invoked by the Supreme Court since 1935. Now, why is it important now? Because the Constitution requires that Congress makes the laws, and over time, Congress has, in effect, given so much discretion to administrative agencies that many observers believe, including many scholars believe, that the agencies are actually the ones who are making the laws, which would, of course, violate the idea that Congress alone is the lawmaker in our tripartite system. The court's interest in the non-delegation doctrine is probably attributable to one person, Justice Thomas, who over the years he has been on the court has continued to express the concern that the court has not been adequately protecting the separation of powers. But it was not until a kindred spirit, Justice Gorsuch, joined the court in 2017 that attention to the non-delegation doctrine seems to have become of interest to the court. In 2018, the Supreme Court suddenly granted cert to a claim by Herman Gundy that his treatment under the Sex Offender Registration and Notification Act violated the non-delegation doctrine. Unfortunately, when the case came on for argument in October 2018, it was only before a bench of 8 justices. Justice Kavanaugh had not yet been sworn in and could not participate. As a result, there was no majority opinion. The plurality opinion, written by Justice Kagan and was agreed to by the four liberal justices, agreed that the non-delegation doctrine, and this is important, they agreed that the non-delegation doctrine was still good constitutional law. But the difference was Justice Roberts, Justice Thomas, and Justice Gorsuch dissented in an opinion written by Justice Gorsuch and held that the facts indicated that the non-delegation doctrine should have been applied to the Gundy case. Justice Alito and Justice Kavanaugh noted when Kavanaugh joined the court, noted that in appropriate cases, they would be interested in considering the applicability of the non-delegation doctrine. In other words, there was a potential majority for reviving the non-delegation doctrine, but no case before the court. In West Virginia versus EPA, which will be argued later this month, there is a case that raises a number of questions about whether the EPA has the authority to regulate and discharge carbon dioxide into the atmosphere. West Virginia and other appellants argue that the Clean Air Act applies to the discharge of pollutants and CO2 is not a pollutant. The respondents argue that the Clean Air Act should be read to include concerns about CO2 and climate change. When the case first arose in the Obama administration, the Supreme Court stayed the the implementation of the EPA's proposal, waiting for lower court review. In the Trump administration, the EPA concluded it didn't have the authority for this rule and discarded it. But the Court of Appeals for the D.C. Circuit, again, resurrected the plan, and the Supreme Court took the case. West Virginia and other states contend that power companies in their states cannot meet the power needs of their citizens if the EPA plan goes into effect. So our book on the non-delegation doctrine turns out to be very effective and useful for this particular time in the court's history. Unfortunately, however, there was insufficient time to get the book into stores or on Amazon before the Supreme Court argument. So AEI agreed that we could make a limited number of free copies available to the Supreme Court and others who are likely to be particularly interested in the book. Later, probably in April, copies will be on sale in the usual way. Meanwhile, there will be an opportunity for those who have joined this conference to hear the views of some of the authors. The first panel this afternoon is made up of Mark Chenoweth and Rich Samp of the New Civil Liberties Alliance. Full disclosure, I am on NCLA's advisory board. After Mark and Rich, we would have had a statement by John Adler, whose essay is in the book, but he is the Johann Verhey Memorial Professor of Law at Case Western Reserve Law School, but unfortunately the weather today kept him out of Washington. So after Mark and Rich, we will hear from David Schoenbrow. David is the trustee professor of law at New York Law School. So let's begin with Mark Chenoweth and Rich Samp.
Is that all right with you? What? Is that all right with you? Yes, go ahead. Right. Oh, yeah. Good afternoon. It's a real pleasure to be here at AEI and to have a chance to talk about a constitutional doctrine that I think is emerging rapidly as an important issue at the court. And I think that regardless of how the court rules in the West Virginia versus EPA case, we are likely to see the court revisit the issue in the years to come. One of the things that Mark and I were struck by when we started looking more closely at the non-delegation doctrine was the fact that, on the one hand, the Supreme Court for the last century has repeatedly said how important the non-delegation doctrine is, that Article 1, Section 1 of the Constitution says that all power to legislate resides in Congress. It's vested in Congress, and that strongly suggests that they aren't really supposed to be divesting that power. The term that is usually used is they shouldn't be delegating that power. We do think that given the language of the clause, perhaps it ought to be referred to as the non-divestment doctrine, but I'm not going to quibble with that language here today. But even though the court has very strongly suggested that the non-delegation doctrine is an important part of the separation of powers, and that Congress has absolutely no right to delegate its legislative powers to anybody else, be it a private citizen or a part of the executive branch of government, nonetheless, it is only, as Peter was saying, has been honored in the breach that since 1935 or 6, the Supreme Court has never struck down legislation as a violation of the non-delegation doctrine. And just why is that? And it seems to me that there are several reasons for that, and we outline a number of them in our decision. But I think the two most important are first of all, if you are a strong believer in the administrative state, as certainly I think progressives tend to be, they look upon the non-delegation doctrine as somewhat anachronistic, that maybe requiring Congress to spell out all the details of rules in their legislation was doable back in the 18th and 19th century, but with the rise of the New Deal and the modern administrative state, that just simply is not possible. I'm not really sure that argument really holds water. I mean, if you look at the tax code, for example, Congress has enacted a piece of legislation that has a huge amount of details, and it has shown itself quite capable of regulating extensively in that area. But nonetheless, I think it's fairly clear that the non-delegation doctrine is never going to be embraced by people who look upon it as anachronistic, and no amount of tinkering with the rules is really going to make a major difference. The other great objection that you hear to strong enforcement of the non-delegation doctrine comes from those who worry about the fact that there is no real bright line in the area. The fact that everybody agrees that on the one hand, it's Congress's role to legislate, but on the other hand, the executive branch has to have a certain amount of discretion in order to execute the law. And where do you draw the line? Well, if you don't have a bright line, then the difficulty becomes that federal judges are not going to arrive at consistent results. Justice Scalia was perhaps one of the strongest proponents of the idea that you need bright lines in order to keep judges in line. And he spelled out that theory probably most strongly in his dissent in the Mistretta case, where he said that given this line drawing difficulty, and why should judges think they are any smarter than our members of Congress? And therefore, since Congress has some pretty bright people, why should they not be the ones to draw the line between what is delegation of legislative power, which is improper, versus what is granting an executive branch official discretion to administrate a law, which everybody would agree is proper. And so while he was willing to apply the line in a very few limited number of cases, and the Mistretta case involving the sentencing guidelines was one case where he was willing to, he wasn't willing to do it beyond that. So what we have right now is what's referred to as the intelligible principle test, under which the courts will uphold legislation as not violating the non-delegation doctrine, so long as there is some intelligible principle that an administrator can follow in terms of trying to carry out the law. Well, the trouble with the intelligible principle test is that it basically has become a non-test. It has become simply any sort of guidance at all, such as please administer this law as you think best in the public interest, is sufficient to survive the intelligible principle test. And so I think everybody agrees that if that wording remains the test, there will be no revival of the non-delegation doctrine. So we tried to come up with rules that would be bright line rules of some sort that could be applied as a way of allowing courts to say that that certain legislation goes too far and it ought to be struck down as a violation of the non-delegation principle. Alan Morrison is a prominent Supreme Court litigator as well as law professor, and he filed a cert petition in a case involving tariffs on steel imports from from China, and I thought that he came up with a good basic rule that courts could apply, and it wouldn't apply in very many cases, but it would at least be a method of restoring at least some teeth to the non-delegation doctrine. And under the test that he suggested to the court in a case by the name of American Institute for International Steel versus United States, was that it should be incumbent on the government, if it is trying to exercise broad powers under a statute, to articulate some limitation imposed on what the government can do. That if the statute says you can legislate in the public interest, well, that sort of statute really doesn't impose any limits on what the government can do. And therefore, such a statute ought to be struck down. Now, it doesn't take very much for Congress to come up with something that imposes a limitation. They can say, well, look at these 8 factors and look at these 3 different possible conditions, and based on something like that, it's probably possible to discern some limit. But in the American Institute for International Steel case, the particular tariff statute in question said that the president has the authority to impose supplemental tariffs on imported steel if he deems that it's important to do so in the national interest. And President Trump said, well, I think these additional tariffs would be in the national interest because, after all, if we allow more imported steel, then people who work for companies that manufacture steel within the United States may lose their job, and it's in the national interest to preserve American jobs. Well, of course, he could have made the same argument in the other direction and saying, well, it's in the national interest to allow the price of steel to drop so that we can make more cars within the United States, and therefore there would be more jobs within the automobile industry. So in my mind, that was a case, that was a particular piece of legislation that had absolutely no limits on what the executive branch could do. And in fact, Alan Morrison in his case said, I challenge the government to come up with some limitation on what they can do under the statute, and the government never really suggested such a limitation. And so to me, that is a sort of ground floor sort of limit on what can be done. Now, that would perhaps provide some benefit, but if there's going to be a genuine revival of the non-delegation doctrine, it seems to me you need something with more teeth. One suggestion that is sometimes associated with Justice Kavanaugh is the idea of expanding the major questions doctrine. Under the major questions doctrine, this is primarily seen as a rule of statutory construction, under which if there is an agency that is trying to interpret a statute in such a way that all of a sudden the agency has the power to do things that no one really ever thought they had that power before, and it would end up with major implications for reordering society, that perhaps that's a reason not to interpret the statute as broadly as the agency is saying. So that one example that's oftentimes cited was that back in the 1990s, FDA claimed the authority to essentially ban cigarette sales in this country, and that would have been such a major change in the way that of government regulation that the Supreme Court said, no, that's not a plausible interpretation of the statute, because if Congress really had intended the Food, Drug, and Cosmetic Act to be interpreted that broadly, that it would have imposed it would have said something in the statute that they intended to give that kind of authority. So the question that was raised by Justice Kavanaugh, as I read one of the concurring opinions that he wrote, is that perhaps that major questions doctrine should be imported into the non-delegation area. That perhaps if a question is major enough that that's the sort of thing where we require the Congress to be the one to write the detailed rules, and that perhaps less major questions, well, we won't apply the non-delegation doctrine there. I think Mark and I have concluded that that really is not an appropriate way to go, because first of all, it's very, very difficult to distinguish major questions from minor questions. If you put it in terms of dollars and cents, for example, there are a lot of major questions out there, like abortion, that don't necessarily involve huge government expenditures, but I think most people would think that is major. Secondly, I don't see anything in Article 1, Section 1 of the Constitution that distinguishes between the delegation of major legislative powers and minor ones. I suspect that people who are involved with the manufacturers of shoes, for example, would think that the government rules that impose restrictions on the manufacturer of shoes would think that that's a major question for them, even though it only involves a very small portion of the American population. So rather than looking at that distinction between major questions and minor questions, the focus of our article was much more on what are the core legislative powers that are spelled out in various provisions of the Constitution. And to the extent that we want to expand beyond what I have described as the general floor on enforcement of the non-delegation doctrine, how can we try to identify core legislative powers that really we're going to take a very careful look at before we uphold legislation that can be seen as a delegation of those powers. And with that, I will turn things over to my colleague, Mark Chenoweth, who is going to talk about how we try to identify what those core powers are.
Well, thank you, Rich, and thank you. Let me add my thanks to AEI for putting this book together and for inviting Rich and I to contribute this article to the volume. Peter, thank you for that. Thank you to AEI for convening the event today. As Rich indicated, as we started looking at this question of how do you come up with a functional test that will actually work, something that judges can actually apply, one of the things that we observed was that perhaps rather than trying to figure out whether a particular piece of legislation is a major piece of legislation or a minor piece of legislation, or how you would draw that kind of a line, maybe it made more sense to look at the functions of the legislative branch that are assigned to Congress in Article 1 and figure out whether or not whatever legislation is being passed in some way is getting rid of or is compromising those constitutional functions of the legislative branch. And if we could identify core legislative powers that Congress needs to hold on to and that it cannot transfer or divest or delegate to the executive branch, then we would be a long way toward identifying a test that Article 3 judges could use in deciding whether or not legislation was constitutional or not. So as Rich indicated, the sort of first cut that every statute ought to be able to survive is this idea that there ought to be something that you can't do as a result of the legislation. And if you can't identify that, well then you're already in the soup. But there is a sort of, if you want to think of it as a stricter or a more stringent version of this kind of judicial administrability or judicially administrable standards test. Maybe that's kind of a mouthful. I'll have to come up with an acronym for that or something. But this judicially administrable standards test would suggest that if Congress has not done enough work on the legislative side to specify the limits of the delegation that it is making, to where the judges can clearly tell what the line is. In other words, the job isn't for the judges to draw the line. The job is for Congress to draw the line. And if Congress hasn't done that, it hasn't finished its work, and the judges need to send the legislation back to Congress for it to finish doing its work before that legislation can be deemed to satisfy the Constitution's requirements for legislation. So one sort of initial note before I get into the various areas that we think constitute this core legislative power is so what if we're wrong? What if judges get it wrong? Well, I would just submit to you that judicial error in the direction of not approving a proper delegation is relatively easy for Congress and the President to fix, because if they meant to do this kind of delegation, then they're going to cooperate to do this delegation again. They'll make it clear. They'll fill in the piece that they missed the first time. They'll figure that out, and they can go on their merry way. However, if the courts were to approve a delegation that, and remember, often the way this presents is from a federal agency. So if a federal agency is doing something that Congress never gave it power to do, if the judges are to decide, oh, actually Congress did give you that power, or they were sort of to run the default assumption that the agency does have that power, that Congress maybe didn't speak clearly, but we're going to go ahead and pretend that it spoke clearly enough to give you this power. If you do that, it's very difficult for Congress to ever undo that delegation, because the President will have every incentive not to cooperate in taking that power away from the federal agency. It's a power that now resides in the executive branch, and there's no reason for the President, at least not from an institutional perspective, to want to give any of that power back to the legislative branch. So you have different kinds of error concern in the former case than you do in the latter case. And from a constitutional perspective, it's much, much more problematic for judges to approve questionable delegations than it is for judges to strike down questionable delegations. Now, in terms of the areas that we looked at that I think constitute core legislative functions, these aren't things that we just came up with on our own or did a survey of Supreme Court decisions or something. These are spelled out by and large in the Constitution itself. And whereas as Rich pointed out, the vesting clause doesn't distinguish between major and minor policy decisions. It does articulate what it is that the legislative branch is responsible for. And so the first of these, and maybe the most obvious thing that is a core legislative function and power, is the ability to tax. Taxation, as Chief Justice Marshall said, the power to tax is the power to destroy. Taxation is something that has long been held to be a legislative power. You can't have executive branch agencies going around and taxing people without legislative power, taking that legislative power away and doing it on their own. If they have the power to do that, then you're combining a very strong legislative power with an executive power, and those agencies become very destructive. And there are some unfortunate examples where that appears to be happening, maybe not exactly in the tax area, but certainly in the self-funding of agencies area. Maybe we can get into that in the Q&A, but I'll just suffice it for now to say that the New Civil Liberties Alliance has lawsuits going against the National Oceanic and Atmospheric Administration, for example, which is trying to set up a self-funding mechanism for at-sea monitors on the boats in the Atlantic fleet for the Atlantic herring fishery. So that's the kind of thing that I think that imposes on this or entrenches on this core legislative power. The second area that I would mention is the spending power. the expenditure of federal funds. And whether we're talking about dispensing of federal property, or if we're talking about more traditional just spending bills, appropriations bills, that's something that Congress needs to be the one to sign off on. It's the power of the purse. That's traditionally seen as a core legislative power. And if Congress is doing something to give up that power of the purse, let's say that it is, instead of making an agency subject to an annual appropriations process, let's suppose that it says, instead of getting your funding from Congress, you're going to get your funding from the Fed. And we're just going to specify that the Fed has to turn over a certain percentage of its money to you every year for you, agency, to spend however you choose. Well, that would be, in my view, divesting a core legislative power, the spending power, away from Congress, giving it directly to the agency. And if you've been following the CFPB at all, you would recognize that I've described the funding mechanism for the Consumer Financial Protection Bureau, which seems quite problematic to me. And fortunately, it's a relatively unique funding mechanism, which is also, as the Supreme Court has said in many contexts, a sign that maybe what's going on here isn't constitutional. The third area that I would suggest is a core legislative function is in the enactment of criminal statutes. And this is another area where you have to be very wary of violating the separation of powers. You don't want the prosecutor defining the crime that it's then prosecuting someone for violating. You want to have those things separated. You want the legislature defining the crime, and you want the prosecutors then enforcing it. And if you have a delegation of that sort in that area, then it's a problem. Peter referred in his opening comments to the Gundy case. I actually think that the court didn't go far enough in Gundy. It probably should have decided that because there was a criminal statute involved there, that it shouldn't have allowed Congress to punt the question to the Attorney General as to whether or not the statute applied not only prospectively but also retrospectively. That's something that should have been decided on Capitol Hill and not over at the Department of Justice building. The Supreme Court didn't see it that way, but I think there are other examples where Congress has enacted criminal statutes and agencies have tried to expand the scope of that statute in a problematic way. Here too, the New Civil Liberties Alliance has been involved in litigation, for example, involving the bump stocks, which Congress passed a statute in 1986 making, not banning all machine guns actually, but rather requiring those machine guns that were in existence to be registered and certainly circumscribing ownership substantially of machine guns. Well, when bump stocks were invented about 10 or 15 years later, initially the ATF looked at these bump stocks and decided that bump stocks weren't machine guns. Then they decided that, well, if they have a mechanical spring in them, then they're enough of a mechanical device that it's causing an automatic function, and maybe it is converting a semi-automatic weapon into a machine gun. But at the same time, it said, but as long as the spring isn't there, then it's not a machine gun. Well, lo and behold, in just the last few years, ATF reversed course and has now said, well, now that 500,000 Americans had purchased these things on the understanding that they were lawful, ATF reversed course and said, no, actually, we're going to treat these things as machine guns. And by the way, being treated as a machine gun means that you're subject to 10 years in prison, because that is the prison sentence that Congress attached to ownership of a machine gun. Even though a bump stock is just an inert plastic device, suddenly the possession of that makes you subject to a 10-year prison penalty. To me, that's a clear example of where Congress enacted a criminal statute, the ban on machine guns, and the ATF has turned that into something that Congress never did, which is ban bump stocks. In fact, Congress has introduced legislation to ban bump stocks on many occasions. It has never successfully passed such legislation. So again, if you are to, from a non-delegation perspective, forgetting about statutory interpretation or any of the other arguments that are out there, or Chevron arguments, anything else that's out there in the litigation about bump stocks, If we're talking about just from a non-delegation perspective, I would suggest that you're trenching on core legislative power of Congress when it comes to interpreting that statute more broadly than what Congress passed. The fourth area that we have identified as a core legislative power is in the resolution of policy disputes. And that means that Congress shouldn't be punting these questions to the executive branch. So maybe the best example of this would be in the Obamacare legislation. There was a question of whether or not abortion services were going to be mandatory or provided under Obamacare. Well, rather than Congress deciding that question, because there were many, well, maybe not many, but there were some pro-life Democrat members of Congress who didn't want to vote for Obamacare if it was going to have explicit instructions that such a thing was included. Congress didn't vote on that, and it punted that question to HHS, and then the Department of HHS promptly decided that abortion services were going to be covered by Obamacare. Well, that Congress did not resolve that policy dispute. That's something that should have been a core legislative function that it should have had to decide, not something that it can conveniently punt to a less accountable entity in the Department of Health and Human Services. Another, the Gundy case, which Peter brought up, is another example of where this sort of policy resolution process was I think dodged. You have to have, under the Constitution, bicameralism and presentment for legislation. But in the Sex Offender Registration and Notification Act, you had the House and the Senate taking different approaches to this question of whether or not there should be retroactivity on the application of the statute. If the House does one thing and the Senate does the other thing, and they can't agree on that, the solution isn't for them to say, let's punt it to the Attorney General and let the Attorney General to decide. That's not resolving the policy. The Senate and the House need to decide, one way or the other, what the policy resolution is going to be, and then hand it to the Attorney General for implementing that law. But it shouldn't be just punting these questions, whether it's to HHS or the Attorney General, particularly when it comes to a criminal statute in the case of SORNA. That's not behavior that Article III judges should be tolerating from the legislative branch or the executive branch. The fifth category of core legislative power that we talk about is that Congress should not be able to surrender its ability to act as a check on the executive branch. Now, we've seen this happen, and we talk in the article about this happening at the state level during the lockdowns in the state of Pennsylvania, for example, where there was a reversal in sort of how law was made. Instead of the state legislature making a law and then the governor signing it, the governor was making all sorts of laws and then saying, well, unless the legislature is able to muster a 2/3 majority to overcome what I've done, then my laws are going to hold sway. Well, fortunately in Pennsylvania, they were able to get a constitutional amendment to undo that, thankfully. But it took a long time, and there was a lot of executive lawmaking that was occurring before that constitutional amendment took effect. At the federal level, I think we see this failure to act as a check on the executive branch again with the CFPB. The Consumer Financial Protection Bureau is exempt under the statute from oversight by the Appropriations Committee because there isn't the power of the purse to control the CFPB. There isn't oversight power to control the CFPB. Congress has effectively, and I think deliberately in the case of the CFPB, because of when it was passed, and I won't get on too far of a tangent there, but Congress deliberately took away its own power to oversee the agency. Again, it's giving up core power, core legislative power. That's not something that it should be able to do. And so if there's a non-delegation challenge to the CFPB, I think that ought to get very serious consideration by the courts. And I think actually, and again, I should say, NCLA has a lawsuit against CFPB on this very question, promoting a non-delegation theory. I do believe that the CFPB cannot survive scrutiny under the non-delegation doctrine, actually even under the current doctrine, but certainly not under the one that is specified in the article that Rich and I have put together. Maybe the last thing that I'll say is that if you're trying to decide in this last category whether or not a particular delegation is lawful, one thing to consider is whether or not the power has been delegated in a way that it's easy for Congress to take it back. The term delegation, when we talk about that, usually implies the idea that it's sort of a two-way street, right? If I'm a principal and I have an agent and I'm delegating some task to that agent, typically we think of you as the principal as having the ability to take that back at any time. If I give you a check and send you to the bank with it, and then I think better of it 10 minutes later and say, you know what, let me just take that myself, I have the ability to take that check back from you and go deposit it myself. But that doesn't always happen when Congress divests the power, and that's why I like the term divests better than the term delegates, because when Congress gives power to a federal agency, it can't take that power back. Congress needs in order to divest the power, there's a vote by Congress and the president signs off on that. To get it back, guess what? Congress has to vote on it and the president has to sign off on it again. So there's no way for Congress to single-handedly bring back that power that it has given up. So I think something that courts need to look at in considering the non-delegation question and in looking at this judicially administrable standards test is whether or not Congress has the ability to get any power back easily. And if it can't, it's not really a delegation. It's a divestment of legislative power in violation of Article 1, Section 1 of the Constitution, and the courts should have the backbone to do something about that. But the backbone of courts is something that Peter has also written about in his book Judicial Fortitude, which I commend to you as well. And I have something to say about the major questions doctrine, but I think I'll just save that for later and leave it there for now. Thank you.
Great. Thank you very much. I think we probably ought to have some questions for Mark and Rich on their subject. So let's do a couple of questions on that. And if there are any people who are observing this from outside and have questions, you can send them in, and we can then propose them to the members of the panel. But let me just start with a simple kind of question, and that is, I think we all get the idea that if there are no standards at all in a statute, like the one that Alan Morrison had to argue, where there was absolutely no restriction on what the president could do for national security purposes, and the court didn't even take that case. They could have, and he made, at every step along the way, he said to the government's lawyers, tell me anything the president can't do under this statute, and they were never able to designate anything. So apparently it was wide open, and yet the court didn't even take the case to deal with a non-delegation question. So a statute without any standards at all should be a violation of the Non-Delegation Act, or non-delegation idea, as you're suggesting. But then you say, if there are standards, then that would qualify, even if the standards are not particularly specific or far-reaching. So let me just suggest a kind of standard. What if the statute said, the agency shall clean the air, but not in areas it deems already clear? There's a standard. There's something given to the agency to clean the air. But there is a restriction. No, if the agency decides that the air is already clean in a particular area, it doesn't have to act. Would that meet the standards?
Well, I think it depends on what it is that the agency is trying to do in that particular instance. If the proposed action directly relates to that standard that you're talking about, yes, it does meet that minimum standard, because that would, the way you describe your standard, I gather you're saying you may not adopt a rule that is designed solely as a total safeguard, that it's like declaring a polar bear endangered because maybe in the future his habitat will be affected because maybe we'll have climate change. To me, that's the sort of rule that would be prohibited by, in the same sense that if the air is clean, you can't prohibit people from doing what they've been doing all along if there's no indication that that it's going to make any difference in the near term, and you can't just adopt a principle of being extremely safe and saying, well, unless we adopt new rules, maybe something will change in the future. So sure, that would be a standard, and that would be enough to meet the minimum test.
I see. Okay.
Let me do a variation on that.
David Schoenbrod.
Right. So I'm going to talk about the actual Clean Air Act. I know about it because I was an air pollution litigator for the Natural Resources Defense Council in the 1970s. It says protect health. The agency must issue rules to protect health. Now, it so happens that Edmund Muskie, who was the author of the statute, said some few years afterwards, well, we knew at the time that there was no threshold between protecting health and not, because we knew that there was some dangers to health down to pollution levels of 0. So doesn't that suggest to you that the business of deciding how much guidance is sufficient is very hard to identify? And if that is so, do you really have a judicially manageable standard?
I think that's why I would suggest putting the onus on the government. The government has to identify something that they can't do under the statute, and if they cannot, then it's a improper piece of legislation. I don't know if EPA ever said that under that standard of you can protect health, if they said, okay, that gives us fairly broad authority, but we admit we can't do X. Unless they can point to X, I would say it's an improper delegation.
Well, they probably could find some pollutants for which there would be a threshold. So they could say, well, for pollutant X, we can't go below this, but for these other pollutants, well, it's not, it's a judgment call. But isn't life full of judgment calls?
And I'm not suggesting that our proposed floor test is going to make a huge difference, but it would be 100% better than the current intelligible principle test.
And life is full of judgment. The question is, who decides? And the answer that the Constitution gives to that question is Congress. Yeah. Congress gets to decide on what the level is. So if Congress is either abdicating that duty because it doesn't want to be held responsible for decision-making in that area, or it just maybe through laziness, maybe through inability to reach consensus, whatever the case may be, it punts that question to the executive branch, then the locus of that decision-making is taking place in the wrong place constitutionally. So it could be that the way that you posed the question, David, might be even sort of easier than the way that Peter posed it, in the sense that if Congress is really telling an administrative agency, you can regulate all the way down to 0 as long as you say the reason you're doing it is health, well, then Congress hasn't made any decision at all whatsoever. So that's certainly not a judicially administrable standard that has been delivered in that statute.
That's a really good point. But let me ask one more question, because I'd like to get some sort of clarity on this difference between the major questions doctrine and the non-delegation doctrine. Because we hear that, in fact, in some of the briefs that I have seen in the West Virginia case, the two are kind of conjoined. They're as though they were the same thing. They are different. So let's go back to the tobacco case that was mentioned, because that's a fantastically interesting case. There, the agency was given authority to prevent the use of harmful, by the American people, the use of harmful chemicals. Over the course of the time that they were given that authority, there were many efforts to get them to regulate tobacco, and they said no. Then a lot of material began to be published in the press saying that tobacco is actually a harmful thing. Why aren't you covering that? The case got to the Supreme Court, At that point, by that time, the agency was already saying, yes, we have the authority because we are supposed to protect the American people against harmful materials. And the court said, no, actually, that's a major question, and we're not going to deal with that because it wasn't part of what Congress was considering at the time that they passed the statute. That sounds as though major questions can be more important than the non-delegation question, because there the power was delegated. I don't think there was ever a question about it. The question was whether Congress had intended to delegate that specific power.
You're right. The major question doctrine is a question of statutory interpretation. How do you interpret a statute? And that's why I don't really think it relates well to the non-delegation doctrine. That in the tobacco case, not only did they say that there was absolutely no indication that Congress, when it adopted the Food, Drug, and Cosmetic Act, intended to cover cigarettes, but it also adopted over the years many, many pieces of legislation in which they did authorize FDA and other agencies to regulate tobacco. So, for example, television advertising was prohibited for tobacco starting in the late 1960s. And that it would make no sense that Congress had intended to allow FDA to totally ban this product if Congress had adopted numerous other pieces of legislation that regulated tobacco in other ways that were short of totally banning the product. And so when you're talking about statutory interpretation, the major questions doctrine makes a lot of sense. But there's nothing in Article 1, Section 1 that talks about you can delegate legislative power, but not if it involves delegation of major questions. And that's why I think they are totally separate questions.
I see. All right, David Schoenbrod.
Thank you.
Let's hear it.
Well, thank you, Peter and John, for launching this project to address Justice Gorsuch's question, what is the test? The test in my chapter is new, and given the test's novelty and the time rush, the time pressure that Peter and John were under to get the uncorrected page proofs done, it's not surprising that there are some problems with their summary of my chapter, of my test. The published book will include corrections. So if you have the uncorrected proof, please heed instead what my chapter actually says and what I'm going to say now. From the beginning, the Constitution meant that Congress may not delegate the power to make rules of private conduct. This is the meaning discussed by framers, by the early Supreme Court, and it's the meaning that I wrote about in my early scholarship on delegation. I'm sticking with that meaning of the Constitution. That's the right one, I think. But I once thought that the test for judicial enforcement should be the same as the meaning of the Constitution, with equitable discretion providing some time for Congress and the agency to adjust to the new constitutional regime. I've come, however, to recognize the test should differ from the meaning because of a constraint on judicial enforcement, the impossibility of Congress complying completely because there are so many federal rules, too many rules for Congress to enact them all. In response to this constraint, the court uses a test that allows Congress to delegate rulemaking authority to an agency if the statute provides an intelligible principle to guide agency rulemaking. As applied, however, that test has founded on another constraint on judicial enforcement. It's not judicially manageable. So the upshot is that Congress could delegate very broadly. Justice Gorsuch's dissent in Gundy seems to call for a test that allows Congress to delegate the making of rules of private conduct, but sets a judicially manageable standard of how much guidance is required. Let's call this the delegation with guidance test, okay? My chapter takes no position on whether the court could make such a test judicially manageable. Instead, the chapter asks, assuming the court can do so, assuming the court could make the delegation with guidance test judicially manageable, would the test be sufficient? My answer is no. It would not be sufficient because the court has the duty to enforce the meaning of the Constitution to the extent it can, and it could do better than just the delegation with guidance test would allow. The rationale for not requiring the court to make all the rules of private conduct is there's too many of them. But Congress could still vote on the most important ones. So if the court adopts the delegation with guidance test, it should also require Congress to vote on the more important regulations. There is now a judicially manageable way for the court to define the more important regulations. In 1993, President Clinton issued an executive order that requires the Office of Information and Regulatory Affairs and the Office of Management and Budget to deem certain agency actions significant. Among the criteria for labeling an agency action significant is that it would bring large benefits or large burdens, or get rid of large benefits or get rid of large burdens, regardless of whether the benefits are more or less than the burdens. So significance is not a question of cost benefit at all. It's just a question of whether something big is going on, either increasing the benefits, reducing the benefits, increasing the cost, or reducing the costs. Something big going on. Now, and this executive order has remained in effect from 1993 on. The court should hold now that new rules of private conduct deemed significant by the Office of Information and Regulatory Affairs, OIRA it's called, shall not go into effect unless their promulgation is approved through the legislative process. Such a test is obviously subject to the objection that a president could tweak what OIRA does in a way that could take a certain regulation out of having to be voted on by Congress. So, I mean, it's clear that there is a risk of evasion there, okay? But the court has adopted other bright line tests that are subject to evasion. The court knows it, but it's better to have some enforcement than no enforcement, okay? And one example, of course, is the one person, one vote. You could deviate from that if you're within 10%, and political gerrymandering is all right, even though it makes some people's votes worth a lot less than somebody else's votes. Moreover, evasion would impose a political cost on elected officials. As the widely respected congressional historian and political scientist David Meyer, who has read the polls, the public overwhelmingly wants Congress to make the major policy choices. A letter from 70 former senators, both Democrats and Republicans, to the current Senate, to a recent Senate, chastised them for avoiding responsibility. There is a lot of sentiment out there that Congress ought to step up to the plate and take some responsibility. However, the court, through its intelligible principle test, shields the Congress from blame by saying Congress has done its job. It's provided us with an intelligible principle, even though that's obviously ridiculous. Moreover, here's yet another reason why I don't think evasion is a big concern. A president who tweaked OIRA to avoid voting on a favorite regulation would make it easier for a successor in office to get rid of that president's own regulations. Furthermore, regulations deemed not significant would still be subject to the delegations with guidance test. Finally, if evasion got out of hand, the court could change its test. One way it could do so is instead of saying that the test is whether the regulation has been deemed significant, to make the test, how does it measure up against one of the most important criteria in the executive order for what is significant. That is whether the action has an impact that is more than $100 million annually. And that could be an impact via giving a benefit, imposing a cost, reducing a benefit, or reducing a cost. Not a cost-benefit test at all, okay? And that kind of standard was brought up in an excellent law review article by Gary Lawson and Steve Calabrese. I've talked about it as well in an article I wrote in the Harvard Journal of Law and Public Policy a few years ago. So there's lots of reasons why evasion, I don't think, is a reason not to adopt the bright line test that I'm proposing. Now, a reason to have the test I'm proposing is it would do a lot more than would the delegation with guidance test to enforce the Constitution. Remember, what the Constitution means is the legislative process has to act to make rules of private conduct. With my test, Congress would have to, the legislative process would have to act to enact the important rules of rules of private conduct. But with delegation with guidance, Congress doesn't have to enact any rules. Just provide some guidance. And we know how meaningful that is, okay? And second, it would be my test would far better than the delegation with guidance test would do a far better job of delivering to the public the benefit that congressional responsibility was supposed to bring. In the unlikely event that the court could so vigorously enforce a delegation with good guidance test that members of Congress would do their level best to really address every hard choice that otherwise might duck, still Congress would not be fully responsible. As Jonathan Adler in his chapter points out, often the rules come out decades after the statute was passed, so the members of Congress who voted for the delegation are out of office. And Jonathan Adler's chapter talks about that at length, pages 166 to 171. And even if the legislators are still in office, the ones who delegated the authority, they could say, well, the agency really didn't do what we had in mind. They got it wrong, right? So delegation with guidance does not make Congress responsible, and responsibility on Congress is what we need. But if Congress has to vote on the major rules, think about the effects, the important positive effects. In voting on the rules, members of Congress will be responsible for regulatory protection that was not delivered or costs that were imposed. That would in turn give an incentive to the agency to figure out how to write the rule in a way that produces more protection for less cost, which would also give an incentive to members of Congress to rewrite the statutes so that it's possible for the agency to do a better job for the public by delivering more protection for less cost. Now, when Richard Stewart, former chair of the Environmental Defense Fund, myself, former NRDC lawyer, and Katrina Wyman, Richard's colleague on the NYU faculty, wrote a book called Breaking the Logjam, showing very clearly how Congress could make the statutes deliver more bang for the buck. And Richard and I went around Congress and we talked to Democrats and Republicans, and many of them said, you know, we think your reforms of these environmental statutes would be great. But nobody wants to take responsibility, so it's not going to happen. That's why we need responsibility. Beyond that, the test I proposed would be entirely workable. As Justice Breyer showed in a 1984 Law Review article, Congress could enact a statute to establish a fast-track process to vote on agency action, on agency rules. It would work like the base closing commission. There'd be deadlines for votes, limited debate, no amendments. You either vote the thing up or down. Of course, the agency would be talking to you before you voted because they would want to make sure they got a majority. And there could be no filibuster. And with the important regulations, the regulations that have to be voted on, being defined under the OIRA executive order, there wouldn't be any more votes. The number of votes Congress now takes on symbolic actions like naming post offices. Well, let me tell you, enacting rules of private conduct, that's Congress's job under the Constitution. Naming post offices, we could do without. Right? Finally, the test I propose would ease the work of the court. Requiring Congress to vote on the significant rules of private conduct would mean that in the really important controversial cases, the court wouldn't have to rule at all. Congress either approved it or it didn't approve it. And that would protect the court from the kind of guff it will get if it tries to enforce the delegation doctrine in the wrong way, because it's going to be accused of being result-oriented. You voted against that one, you struck that one down because you didn't like that rule, but you upheld that rule because you liked that rule. Now, however, with my proposed test, the rules that would need to be voted on would be determined by OIRA, not by the court. That's an advantage in real life. Okay? So up to now, I've assumed the court could come up with a judicially manageable delegation with guidance test. And I've tried to show why I think my test would be a useful addition to that test. If the court cannot come up with a judicially manageable delegation with guidance test, there's all the more reason to do what I'm proposing.
Thank you, David. Let me ask one question.
Sure.
Your proposal applies to all actions by Congress?
Well, I've only really addressed rules of private conduct.
Of course, rules of private conduct.
Yeah.
But the only ones that can be voted on by Congress are matters that involve more than $100 million.
Oh, that's a very good question. It's a very useful question. Thank you. In setting up its voting procedures a la Breyer, and by the way, James Landis, another famous New Dealer, was also in favor of the same kind of idea. Congress could widen the scope of what it wanted to vote on, make it $50 million, have other sorts of criteria. And so to the extent that the president was fooling around to get really important stuff freed from having to be voted upon, not only would the president take blame from the public for ducking the hard choices, Congress would too. People would say, why don't you arrange things so you have to vote on these, so you get to vote on these things? So the point is, the Congress could take more responsibility, and I say, be my guest.
What about a really important matter that deals with the American people in general, but has no dollar impact?
Well,
You can imagine a violation or an alleged violation of free speech or something of that kind. What do you do about that?
it's a good question. Well, first of all, my first response would say there's lots of non-monetary impacts that we nonetheless monetize. I mean, for example, actually in Stephen Williams and Doug Ginsburg's opinion, in the D.C. Circuit opinion that went up to the court in the Whitman case, they talked about well-known techniques they use for regulations that extend people's lives by, and there are techniques that in cost-benefit analysis for things like health protection and monetizing that. Now, maybe, and of course, even though we say life is priceless, now maybe there are similar ways of monetizing free speech or whatever, I don't know. But the fact that there be some areas where the test, let's assume some areas where the test wouldn't work. Well, I'd rather have something than nothing. And so I say, let's have it go where it works, and then maybe Congress will come up with some other way of dealing with things like free speech.
Okay. Any other questions that people have? I see that John Lee has stepped out briefly, so we'll have to.
Well, one thing we say in the article is that we don't purport that the list that we have given is complete. So I think to the extent that you or someone else can make a persuasive case that there is another core legislative power, and I think you just made a pretty strong case for 3 additional core legislative powers right there, I think that there would be room for the doctrine to, or the test to encompass the protection of more legislative power. The goal that we have is not to reduce the scope of the test. The goal that we have ultimately is to ensure that the locus of decision-making is where the Constitution puts it. So if there are other places like the declaration of war or like the coining of money where the Constitution clearly puts the locus of decision-making in the legislative branch, then it ought to stay there. And if there's a role for this test to play in ensuring that it does stay there, I would have no problem with the judicially administrable standards test applying in those sorts of situations.
I agree with what Mark had said. Let me just add a couple of things. We're trying to adopt a judicially manageable rule that would allow lower court judges to take those rules and apply them in a uniform manner. And that sort of analysis suggests that there has to be a limitation on the number of functions that should be considered to be core. And we've identified, for example, taxing power and spending power as ones that most people would think of as most core, and that some of the other powers that you mentioned perhaps are less so. And I think that if judges are to keep the rules relatively clear and straightforward, they're going to have to arbitrarily cut it off somewhere. I do think your mention of power over military matters is certainly a very controversial area, given that the president has an awful lot of powers himself over the military and foreign affairs, so that I'm not sure that I would agree that that really should ever be part of what we would consider to be core legislative functions.
Okay, well,
but suppose that the
yes.
Congress passed a bill that said, we hereby delegate the power to declare war to the Secretary of Defense. Surely that would be unconstitutional.
Yes, I would agree with that.
Okay.
We'll close this panel with a general question that came from the floor from someone who is watching us. And I thought it was an interesting question because it's so general and has been talked about a lot. Justice Kagan is famous for saying that if you ever declare the non-delegation doctrine to be applicable, it would make all rules that have been made by Congress, made by agencies over the years, unconstitutional.
Most of the federal government, I think she said,
Most
would
of
be
the federal
unconstitutional.
government would be unconstitutional. That's it. So, actually, in the book, Doug Ginsburg deals with this question. And so what I'm going to suggest is when this book comes out, for everyone who's watching this, look at Doug Ginsburg's essay, because it does deal exactly with this question. I won't ask the panel to respond to it now, but since it did come from someone outside, I'd like to make sure that people understand that that question can be dealt with, and he dealt with it very effectively. Okay, thank you, panel. You did a wonderful job, all of you. And now it's John's turn, John Yoo, and his panel.
Well, welcome back, everybody, for the second panel of our conference on the administrative state before the Supreme Court. The new book by Peter Wallison and me. Actually, we barely wrote any of it. Everybody who wrote it are the people here who like to work for us for almost free. The book itself, as Peter said, is available just now, but really won't be up for sale for a few weeks. Before we get to the panel with our great speakers here, there are a few thanks we have to give out. First, to Edward and Helen Hintz. This is part of the Edward and Helen Hintz Book Forum at AEI. These forums provide a platform to host prominent authors for discussions of forthcoming books on issues of national significance, and we are grateful to them for their tremendous support of AEI and deep commitment to our mission. I also remind people who are watching the webcast live, and we know from Peter there's at least one person because they submitted a question. Please email your question to sophie.rizzieri@aei.org or Twitter, hashtag AEI on delegation, AEI-NONDELEGATION. I guess it's AEI non-delegation, right? Yeah, sorry, I mispronounced that one. Also, we should thank Sophie Rizzieri and Nicole Penn, who are here, for helping not just plan this conference, but doing a lot of the work on the book itself. Did a great job. It is not true that the default cover for every AEI book is the Constitutional Convention, though you might think so, but they did a great job, I think, with everything relating to this book. I want to thank Peter, my co-editor. He may not remember the idea for this book, but the idea for this book, I distinctly have a memory of him sitting under a birdcage, because we were sitting in a room at Sea Island, Georgia for an AEI event, which is known as the Garden Room, and there's a bird with a bird cage, and I thought that the bird was going to drop something unpleasant on Peter the whole time he was talking, but luckily nothing happened. And it was... I think I should be in the cage. That's right, Peter wanted to get in there with the bird. Right? But it was from that one conversation years ago, without any consideration of when the court might take up a case and the timing or so on, that we thought, why don't we pull people together to answer what many people who teach this subject think of as one of the hardest questions in administrative constitutional law, which is what is the legally administrable test for a real non-delegation doctrine? And from that, we worked on this book for more than a year with the co-authors, all of whom handed in their things and went through that process with us. And just by chance, it happens, the book is coming out right when the court has taken 2 cases for oral argument this spring on the very question. So it's great. As usual, AEI really is running everything behind the scenes, it seems, just like what people really believe at times, including the Chinese government, it seems, who seem to be reading all of our emails all the time. But I also would like to thank, there's a few authors who couldn't make it, and in particular, there are people who couldn't make it who were supposed to be here before the storms. Joe Pistel was supposed to be on our panel, who's an associate professor at Hillsdale, who's a wonderful chapter on state non-delegation. It's rare when people from Michigan actually can't get somewhere because of snow. Usually they come everywhere and say snow never stops them, but the snowstorm this last few days was so bad that Joe Pistel couldn't make it, along with Jonathan Adler. But I also would like to thank the first panel's authors, and then let's turn to our authors here. They'll speak for a few minutes from the podium, and then we'll come back, sit down. I'm going to ask them 1 or 2 questions, and then we'll turn to the audience. First is Todd Gaziano, who is the head of legal policy and strategy at the Pacific Legal Foundation, and also heads the Center for the Separation of Powers there. Todd is a well-known figure in Washington legal circles. We first met, I think, we were both young staffers on the contract with America Congress. Do you remember this? That we were so excited when the Republicans took Congress for the first time since the early 50s, right? That we both...
Everything was going to change forever.
That's right, we were there. Everything was going to change. We were going to end lobbying, if I remember. That was the meeting was about. Lobbying would end in Washington.
We're going to compensate takings. We are going to...
Yeah, so it's been great. Gary Lawson is here from Boston University. He's the Beck professor. I think it's great to be here because David and the first panel and Gary on this panel, I think, are the ones who are intellectually responsible for the rejuvenation of the non-delegation doctrine in your work, right? You start writing about it when no one cared, right? I mean, it's fair to say, right? You both brought it back from, resuscitated it, I think, and so it's great that you both are here. I think without either of you, I don't think we would be at this state. So it's great to be with the people who were there at the beginning, as it were. And then we have Sai Prakash, who's the Monroe Distinguished Professor at the University of Virginia. And our personal connection is that Sai and I shared an office together for a whole year at the Supreme Court when we both clerked for Justice Thomas, where I did my best to defend the administrative state, actually. My recollection is telling Sai and Justice Thomas and other clerks that you just can't throw out 75 years of precedent like that, which was greeted by peals of laughter, if I recall, at the time. I didn't think he was serious about this, but apparently he was. So thank you again to all of you for coming today, but also to this panelists for this part of the conference. And Todd, please begin.
Thank you, John. Thank you, Peter. Thank you, Sophie, and everyone else. This is a wonderful event. My co-author, Ethan Blevins, regrets that he can't be here today, but we're both delighted to also be included in this wonderful book, particularly with such distinguished scholars that submitted chapters. I'm going to walk through the key non-delegation insights in our chapter, which do concern how the void for vagueness doctrine that the Supreme Court and lower courts have used for almost 200 years, but in a particular mature form for about 100 years, could easily serve as the test for the non-delegation policing in at least a very significant core of cases. And that includes two caveats there. But I'm first going to digress and talk about just a few observations on the legal state of play, including one that the prior panel talked about. So, and maybe John will have us pick the fight a little bit more. First of all, there's no question that it's a more propitious time to reconsider the non-delegation doctrine than any time in the last 86, 87 years. There are as many as 6 justices willing to at least think seriously. 5 justices have said so. The most recent one, Justice Barrett, hasn't said anything while on the court, but hopefully would be along for the enterprise. But I am not among, like I should say, Rich and Mark in the prior panel, I'm not really a big fan of expanding the major questions doctrine as a non-delegation substitute. Now, I think it makes some sense to limit wrongful, illegitimate judicial deference doctrines like Chevron, but even then I have some questions about the definition of what is a major questions. If it is a substitute for those wonks, if it's, I could elaborate later, but if it's a substitute for the Wayman distinction, if major questions is expanded in a way, maybe it could work. But my major thought is it works better in the non-delegation, but my real concern with it is if it is used as an excuse not to seriously reconsider the delegation doctrine. For example, if the court overuses it and interprets, narrows a statute where Congress really was just punting on a major policy question, they might be tempted to do so. It'll prevent the court from reaching the constitutional question. If they do that often enough, there won't be an incentive to examine it at all. And there is an appropriate constitutional avoidance doctrine, but justices have sparred over its overuse as well, and I'm submitting that that's a little bit of my fear. So I think that its application makes sense in the West Virginia versus EPA case, but I have reservations about that. Its overuse. My second sort of prefatory remark relates to John's concluding chapter, where he compares and contrasts some of our approaches on the non-delegation tests, primarily whether our principal approach is a clear rule or a judicially administrable standard. And he's certainly wise to discuss some of the advantages and disadvantages of standards versus rules. But I want to make a couple points about that. First of all, I do still think there's a fair amount of overlap between some of our standards and how the tests that are articulated would resolve some of the most important cases. So I still think there is, I think, a lot of wisdom no matter how the court goes. But even more interestingly, John said, in his infinite wisdom, that the courts might be more comfortable starting with a standard, a more indeterminate standard, maybe like the one my co-author Ethan and I advocated, but then after experience start settling on some rules. And that actually does relate to a point that Ethan and I made, which is that we don't think that any one particular test will cover the playing field. As part of our analysis of that looks at some of the things that Justice Gorsuch identified the courts may want to allow broader delegations on. There's a shared power situation. There's a sort of fact-finding situation where Congress announces what the consequence will be, but then leaves it to the administration to find the facts that would trigger the administration. We suggest that at least in those areas, a different test other than the one we proposed would be more appropriate. And I don't think that we should be surprised that in a constitutional area like this, that there is one unified field theory that would cover all the non-delegation universe. And we discussed that a little bit in our chapter, some other areas of First Amendment law, where there's many complex tests, and that it's good that maybe the Supreme Court didn't know that it would need so many tests when it started to enforce the First Amendment, or it might not have gone down that road. But this is all part of my advice to the courts, not that they listen to me, but maybe you'll repeat it and they'll listen to you, that just because something might take several tests doesn't mean that you shouldn't begin with case one. So now let me turn to summarize, I think, our basic insight. And that is that we argue that the court ought to apply the void for vagueness doctrine more broadly than it does now, which applies primarily to police criminal law delegations, and apply it more broadly to any law that delegates vague yet coercive penalties. Now, this void for vagueness standard, fairly well known to lawyers and even some, lawyers on TV. But this, let me discuss some of how it works and some of the advantages of it for a non-delegation standard. First of all, it addresses both two constitutional problems: a problem of notice, lack of notice, and a separation of powers violation. So under the void for vagueness doctrine, laws must be clear and detailed enough for one, to provide the fair notice, and two, to ensure that the lawmaker and not the law enforcer is making the fundamental policy decisions. So fair notice satisfies the due process requirement, but only congressional legislation satisfies the separation of powers problems. And this is exactly, particularly the second element, is exactly what the non-delegation doctrine is supposed to satisfy. And so that's one of the reasons we say it's an appropriate test to apply in the non-delegation context. Now, of those two problems that the void for vagueness doctrine satisfies, the one that's better known to lawyers and is the fair notice situation. And the classic example of a statute that violates the Constitution as void for vague is a municipal statute or other law that delegates the power to police to arrest people for vaguely defined vagrancy or loitering. Yet, we go through a number of cases in our chapter and point out that clarity at some point isn't enough. And I would offer the following hypothetical. We could imagine a law where the city council delegates to the police or instructs the police to come up with a very, very detailed loitering statute or loitering or vagrancy code and post it. That would probably satisfy the notice requirement, but it wouldn't satisfy the court's, the separation of powers problem that the court has addressed in its void for vagueness doctrine. So what's the main advantage of incorporating this doctrine and just expanding it from the criminal context to the criminal and to the civil, or at least a large class of civil statutes? It's that they've issued hundreds of opinions. The Supreme Court has issued dozens of opinions. And one interesting note that many speakers on this panel today and have written about it, and that they say that the Supreme Court hasn't struck down a statute under the non-delegation doctrine since 1935. And it's led one sage, legal sage, to say that the non-delegation doctrine really only had one good year. But its sister, the void for vagueness doctrine, has only grown in strength. And there are these hundreds of lower court opinions, which at least belies the notion that the courts can't do it. So let me discuss a little bit more before I sit down the kind of cases that we go through. First of all, we go through about a dozen cases where the court has at least talked about the separation of powers aspect of the void for vagueness doctrine. And I'll just quote one, Graynard versus City of Rockford from 1972. Quote, "A vague law impermissibly delegates basic policy matters to policemen, judges, and juries for resolution." But since 1980s, the Supreme Court has emphasized this aspect of the void for vagueness doctrine even more than the notice problem. Maybe at least it's thought that the lawyers get the notice problem. And part of what the court has done in these decisions we go through is it tries to distinguish the kind of discretion that's inherent in any law where some sort of enforcement discretion is required from those where it goes beyond the reasonable amount of enforcement discretion and amounts to creating a law. Well, that's exactly what the non-delegation test ought to be. So again, we go through several of these cases to show that the court has time and again confronted this challenge without flinching, because it started some time ago. And Gary pointed out to me, but now it makes sense, that Scalia, who was quite skeptical of reinvigorating the delegation doctrine, was one of the champions of the void for vagueness doctrine. And there was agreement among liberal justices, conservative justices, on the void for vagueness doctrine. And it's just, yes, the judicial opinions under the Fourth Amendment unreasonable search and seizure requirement is also judicially, based on judicial jurisprudence rather than too much additional guidance from the text. But it's curious that they didn't show as much reluctance in the void for vagueness doctrine as they fear or they express in the delegation area. Let me conclude with just three other brief reasons to support a broader application of the void for vagueness doctrine. The first is that the void for vagueness doctrine is most frequently used in the criminal law context, but not exclusively. It's also used to police certain non-criminal speech restrictions and deportation statutes. Why deportation statutes? Well, that was thought to be important. So it's the criminal, non-criminal distinction really doesn't work. And we point out some areas where the doctrines don't quite mesh, but we suggest how they could easily be harmonized. Second, I want to return to the point that the vagueness doctrine isn't just about fair notice. Now, some of the decisions admittedly do focus on the ad hoc nature of the police making the decision, but we point out at least 3 Supreme Court decisions where there was a motion picture censor board, there was a local motion picture censor board, or let's see, a jury or a judge did actually deliberate. And yet the Supreme Court struck it down, and the Supreme Court's reasoning was they can't fix the meaning of the statute. It's not enough for the motion picture board to fix the meaning of the statute. The meaning of the statute has to be fixed by the legislature. So no amount of deliberation, aka rulemaking, can liquidate the meaning of a statute. And I might remind you that law professor Elena Kagan once referred to the notice and comment process as a charade, but she was right at least if she was saying that that doesn't substitute for the kind of constitutional deliberative process of Article I lawmaking. And then my final point is to return to this notion that, and maybe I skipped over it, so I'll dwell just a teeny bit more, on when the Supreme Court was developing the void for vagueness doctrine. One of the reasons I think it applied it only, or primarily at least at that time, to the criminal law was that the penalties for civil violations weren't common and they weren't severe. But that's no longer the case. Justice Gorsuch has noted this not only in his Gundy dissent, but in another opinion, Demira, but it's demonstrably true. We know that many of the federal statutes have both civil and criminal penalties for the exact same conduct. And those civil penalties are severe, loss of license, civil commitment, you could ruinous fines. The main difference is that the criminal defendant has better defined due process rights. So if anything, it's more important to apply a doctrine like the void for vagueness doctrine or its analog in the non-delegation doctrine to civil offenses. And the final thought is specifically with these dual use statutes that have both criminal and civil offenses. The Supreme Court has also said that courts can't interpret one of those statutes differently, depending on whether it's a criminal statute or whether it's a civil statute. If that's so, does it really make sense to only apply the void for vagueness doctrine in the criminal context? I submit no. So, thank you.
Thanks. Thanks, Todd. Gary? Thanks.
Hi, thank you. As John Yoo said, I've been an administrative law junkie for about 4 decades now. Change that. I've been an administrative law nerd for about 4 decades now. And because the delegation issue is fundamental to almost everything that happens in administrative law, I've been obsessed with the delegation question for a very long time. And I'm therefore really grateful to John and Peter Wallison for bringing me into this project, because it's made me ask a somewhat different question than I've normally been asking. I've had to ask not what would be an intellectually interesting approach, not what would be an interpretatively correct approach, what would be an approach to delegation that actually has some utility in the real world. And in doing that, I realize that I end up saying several things that I never would have said 30 years ago, wouldn't have said 20 years ago, maybe would have fumble-mouthed inarticulately 10 years ago, but not quite. One of those has to do not so much with the answer to Justice Gorsuch's question that prompted all of this, what's the test, but rather, where would one go to look for the answer to that question? And first response would be, well, my gosh, this is a question of constitutional law. Well, wouldn't we therefore go look to the places where constitutional theorists look for the answer to constitutional questions. You look at the Constitution, its text, its structure. You look at founding area materials dealing with the drafting and ratification of the document, political theorists who are likely to have influenced things, and all. I'm not saying anything bad about all of that. I do that, as a career. So nothing wrong with doing that. But I wonder whether that puts you in the position of Belloc in Raiders of the Lost Ark. You've got half the coin that goes on the staff of Ra, but there's another half that you don't have. And as a result of missing that other half, you are digging in the wrong place. So one question is whether a lot of us, including myself, have been digging in the wrong place for quite some time. The second thing that's different that I wouldn't have said in the past, and this echoes some of the things that Todd Gaziano just said, maybe it's a mistake to be thinking about the non-delegation doctrine as though it's a unitary thing. Maybe it's not a doctrine at all, but a series of doctrines, or maybe even more accurately, a series of questions that varies with function, with context, so that Justice Gorsuch shouldn't be asking what's the test, but rather what are the tests. Let me say something about both of those. All right, what other than the usual sources of constitutional materials might bear on the question of delegation? And my suggestion is that maybe what some of us, including me for a long time, have been missing is what happens in the ordinary lives of people and their lawyers in the founding era. Questions about delegation and then sub-delegation, delegation of delegated authority, did not begin with the Constitution of 1788. They did not begin with the state constitutions of 1776 and following, some of which contained explicit separation of powers statements seemingly more powerful than anything you could derive from the federal Constitution. No, these questions were around for centuries beforehand, not so much in the context of government as in the context of people's ordinary affairs. There were lots of times when people found it useful to entrust management of some portion of their affairs to someone else. Lots of settings where you'd find that. If you own a farm, you're away from it for a while, or maybe you're just lousy at running farms, you might want to hire somebody, a steward, to manage the farm for you. Now, the expectation is that steward is going to manage it not to maximize the steward's own income or satisfaction, but on your behalf. Today, we would call that kind of relationship a fiduciary relationship, where somebody is obligated to act on behalf of someone else with someone else's interests in mind. They didn't have the vocabulary of that in the 18th century, but they had all of the reality and all of the concepts. Lots of other contexts. Guardians for children, if you are absent or perhaps deceased, managing the affairs and assets of those children. You're trying to sell your goods overseas. Well, probably you're not going to own your own shipping line, so you're going to entrust the goods to a shipper. They called them supercargoes. And then once they're in the foreign country, there's going to be some business agent, they called them factors, to arrange for sales. All of these are circumstances where one party is entrusting care and management of some portion of its affairs to somebody else. And the first strategy for dealing with those kinds of things is contracts. Parties can make whatever arrangements they want, but as anyone who's been to law school knows, contracting, it's expensive. It's expensive to negotiate them, to write them, to enforce them. Law often helps parties out by providing default rules, background norms, things that contracts can be drafted against. As long as everybody's happy with those background rules, they can concentrate just on the things that are controversial. You don't like the background rule, you draft around it. Well, by the time the 18th century comes along, one of the most powerful background rules governing these relationships of trust and management was a principle of non-delegation, or more precisely, non-sub-delegation. The principal delegates authority to the agent. Nobody had any problem with that. The question then was whether the agent could, or indeed in some cases must, subdelegate some of that authority to somebody else. And here's the thing, by the time you get to the 18th century, the background rule on that was a very powerful presumptive rule against subdelegation. There is an avalanche of sources on this, and to my knowledge, not a single source from that era to the contrary. Just one example. This is from Matthew Bacon's New Abridgment of the Law from 1730. This was a hugely influential work. This was the go-to source for any 18th century lawyer on a wide range of questions. It says, one who has an authority to do an act for another must execute it himself and cannot transfer it to another. For this being a trust and confidence reposed in the party cannot be assigned to a stranger whose ability and integrity were not so well thought of by him for whom the act was done. And as I said, I could multiply that many times over. All right, well, that's fine and dandy. What does any of that have to do with the United States Constitution? Well, let me add two more items of information to see how that connects. Item number one, the Constitution of 1788 is, and I'm even going to add an adjective, is obviously a fiduciary instrument of sorts. It is a principle identified in the opening statement of the preamble as we the people of the United States, vesting some portion of management of its affairs to a series of agents: Congress, President, Vice President, federal courts, presidential electors. I mean, there's a whole series of agents identified in the instrument. It's possible to argue about exactly what kind of fiduciary instrument the Constitution most closely resembles. For this purpose, it doesn't matter, because that entire family of fiduciary instruments was governed by this presumptive principle against subdelegation. And anyone who was involved in the process of constructing the Constitution of 1788 would know this. The actual authors of the document, 5 people on the Committee of Detail, they were 4 lawyers and a businessman. What did the lawyers do while they were lawyers? They drafted, negotiated, and implemented agency instruments. What did Nathaniel Gorham, the businessman, do? He executed agency instruments, entrusting authority to others. This was all very, very well-known stuff. So if the Constitution fits elegantly into this network of documents, this background rule, if you grant authority to somebody, well, of course they're supposed to execute it themselves, or you wouldn't have granted it to them. Would have given it to someone else. That's just part of the background that the Constitution is enacted against. And if you want to refer to more conventional sources, all of them overwhelmingly, in another avalanche, support the same thing. Just one example. The Constitution is obsessed with how you select members of Congress. The notion that it has that obsession just to make sure that you've picked the right people who will then punt off their authority and go to the Bahamas is absurd. It's just, you cannot maintain that with a straight face. So I think there's a very, very close connection between these ordinary private law arrangements and the background legal rules that would have been familiar to everybody, not just to the lawyers, right? People in the 18th century, they're the ones who are hiring the stewards. They're the ones who are worrying, given life expectancies in that time, what happens if we leave minor kids? This was everyday stuff. So I think there's good reason to draw a very straight line from these, what we today call private law ideas, to the background rules of the Constitution. Here's the second observation. That background common law rule was a presumption. There were recognized exceptions. There were times when it was okay for agents to subdelegate their authority. 3 circumstances in particular. 1, the agency instrument could expressly authorize it. 2, there might be a custom in the business or trade that is so well established that it would supplant the presumptive non-subdelegation rule as the background rule. And third, sometimes just from the nature of the transaction, from the nature of the function that the agent is performing, it might be so obvious that subdelegation is permissible and in some cases even mandatory that they didn't need to write it into the instrument. It was too clear. The classic example here would be when you entrust an agent with a task that for some part of it is going to require a lawyer or a licensed auctioneer or something like that. Was it really the expectation of the parties that the agent was going to go to law school, become a lawyer, or go and get a license, then 5 years later get around to it? No, everybody knew they were going to get the lawyer to do what the lawyer had to do in order to make the transaction complete. Well, if that too is part of the background against which the Constitution was drafted, then when we start to ask, what's the test? Well, can you really answer that question without asking, okay, what's the function? What is the agent being asked to do? What in the context of what the agent is being asked to do in this particular circumstance reflects, is there any express authorization for subdelegation? I can answer that one for you. No, there's no place in the Constitution that authorizes Congress expressly to subdelegate its authority. Custom in the trade or business, very, very hard to find a custom for the kind of separation of powers regime reflected in the founding era American constitutions, either the state constitutions or the Constitution of 1788. It was a relatively novel set of arrangements. It's not like there were centuries of practice about this. There wasn't even a judiciary power as a separate power until a few decades before the American Revolution. So no custom or practice. What about this notion of, well, it's so obvious, there's such an obvious necessity for this that it would go without saying? Or, another tale of the distribution, it's so trivial a function, so unimportant, that surely the principal didn't expect the agent to do it, right? You hire the supercargo to carry your goods to France. Do you really expect the supercargo to swab the decks? I mean, if you do, you can write it into the arrangement. I want a supercargo who's going to swab my decks. But if you don't say anything about it, nobody would think the supercargo has to swab the decks. That's just not the sort of thing you would expect the parties to contemplate the agent would do. But you'd only come to that conclusion by looking at what the agent was actually expected to do. So that's where the Gaziano principle comes in. There are a lot of things that Congress, as the agent, is charged with doing. A whole list of various functions of Congress. It might very well be the case that the best we can come up with here is a general approach. The approach of looking for the background common law understandings that would have informed the Constitution. Looking for analogies in the quite extensive case law of that era that dealt with these questions in a wide range of private law contexts. And then going down function by function, power by power. I have to give a shout out here to a up-and-coming scholar and just got hired this year at Catholic Law School, Chad Squidieri, who's written a terrific article making exactly this point, that there might be a lot of different non-delegation doctrines for each specific power. He doesn't frame it in the private law fiduciary terms that I just did, but it would be a very, very elegant fit. Anyway, that in essence is my contribution to this process. Again, not so much providing answer as providing a place to look for answers and a framework for figuring out how to formulate the questions. And oftentimes, that's 80% of the battle. And we'll leave it, hopefully, to the courts to fill in the remaining 20%. That, in any event, is where I am in 2022. And we'll see if I'm still there in 2023, but that's where I am right now.
We'll see where Gary thinks 40 years
from
now.
Exactly.
Yeah. Thanks, Gary. Cy,
thank you.
Why don't you go ahead? Then we'll open up for questions. And I'm already getting questions from the online audience, quite good ones, so please send those in as well.
Well, it's an honor to be here today and to be part of this project, and thanks to John and Peter for inviting me, and thanks to AEI for putting together this excellent book. I understand it's not quite finalized, but operators soon will be standing by, and I'm sure it'll make a wonderful gift for people who need to know more about the administrative state and the non-delegation doctrine. I was flattered to be asked to participate. Larry Alexander and I had written an article several years ago about what else might be delegable if delegations are permissible, the sort of delegations that are common today. It was called Delegation Really Running Riot, and we made sort of 2 points about the non-delegation doctrine. One, every delegation to an independent agency in particular is a negation of the president's veto. It's commonly thought that delegations are delegations of congressional power, and they are in a sense. But to the extent that they're given to entities over which the president doesn't have any control, they're actually negating the presidential veto, right? Because the president doesn't have the opportunity to veto the legislation that's taking the form of a regulation. And that raises interesting questions, right? Where you might think there's some authority for Congress to delegate its legislative power, but is there authority for Congress to basically strip away the president's veto? The second thing we pointed out is, well, what else can Congress delegate? Can it delegate its power to make amendments to the Constitution? Can it delegate its power to impeach? Can it delegate its power to make rules? And then, of course, you could ask similar questions about other entities, right? Gary's discussion, I think, is apropos. Can the president delegate the power to pardon? Can he delegate the power to veto? There are all sorts of rules about who gets to become president. Can the president delegate it to a foreigner, right? To the power to pardon or the power to veto. Can the courts, right, delegate to one of their clerks the power to decide a case? Just imagine a clerk sitting up on the bench with the rest of the justices. I share Gary's intuition. I think most of the authors share Gary's intuition that the Constitution carefully prescribes who may exercise particular powers and how they may exercise them. That's true for the amendment process. It's true for the veto. And it's certainly true for the legislative process, right? It's a very extensive discussion in Article 1, Section 7 about how to make laws, and it doesn't involve some agency composed of 5 people or less making rules through some process prescribed by Congress. So I share all those intuitions that Gary and other people have. And I guess I'd further say is, there's a lot of solutions that are to be found in this excellent book. And I think it's possible that the court could draw upon them all, right? It's possible to have a test that runs through David's test for significant rules that adds Todd's test to it. And so you have to satisfy multiple criteria in order for the court to conclude it's not a delegation of legislative power. There's really no reason to fixate, I think, on any one of these solutions. I think they're all great and they're all plausible. I think I, like a rebellious American, didn't quite follow the instructions that John and Peter provided. The instructions were to come up with an administrable test for the non-delegation doctrine. And I thought about it for a while, and I thought, well, these other smart people, they'll come up with administrable tests. Why don't I do something slightly different, which is to discuss the transition issues that arise from moving to really a non-delegation, non-doctrine, right? There's really nothing in the intelligible principle standard to a more robust standard where, of course, the court will occasionally be striking down statutes as delegating legislative power and therefore nullifying or voiding rules that were issued pursuant to those delegations of legislative power, those unconstitutional delegations of legislative power. And so I thought about the transition issues and how to mitigate them, because one of the concerns that people often express is, well, there's going to be a catastrophe, right? The sky will fall if the court ever adopts a non-delegation doctrine with some teeth. And I think for many reasons that doesn't have to be the case, and it won't be the case. I don't think that the court will allow the sky to fall. I think it has too many pragmatic justices who will make sure that doesn't happen. And then I think all the institutional actors here have a role to play in managing that transition. So I think the first thing is if the court revise this doctrine, and we're waiting for them to do so. There are teases that they might do so here and there. But if they do so, I don't expect that they'll have fully liquidated the idea in the first case. That is to say, I think they'll be groping around for principles. They might announce some reasons why the first statute they strike down is unconstitutional, but I don't expect that they'll come up with a test that they are going to be applying going forward that's fully detailed and explicated. And so there will be a level of uncertainty as to what is unconstitutional or not, and I don't think they'll be very precise about that, at least in the first case, because they'll be sort of feeling their way through what to do. And so there'll be time, right? There'll be time to adjust to the new test as they develop it, right? I just don't think they're going to come up with one in one particular case. And even if there are, say 3 or 4 justices that want a particular standard, you might have other justices who want to take time and think about it. Because you might think that the initial case will be more focused on should we revive the doctrine rather than what is precisely going to be the standard going forward. And so when you think about the institutional actors that can play a role here, it's of course the court and the agencies and Congress. And some of the other chapters in the book, I think, discuss this. I think David's chapter discussed this, as does Judge Ginsburg. But my chapter really focuses on what each of these entities can do. And so with respect to the courts, I've already described how they can sort of muddle their way through to getting to a more prescribed test over time. But they can do other things as well. And so in my research, I found that the court often delays adjudicating a case or making its judgment final in order to give Congress time, or in order to give other parties time to react. And these sorts of instances have occurred throughout history. Of course, Marbury versus Madison was filed in 1801. They didn't decide it until 1803. That wasn't the court deciding to delay, that was Congress, right? Congress abolished the 1802 term. But those sorts of delays have continued on to this day. There's a case involving the Nuclear Regulatory Commission where someone challenged an NRC rule, and the court granted certiorari and did not decide the case until 2 years later. I think they were waiting for Congress to supply a statutory solution. Congress did supply a statutory solution to the problem at hand, and then I think they dismissed the case as improvidently granted. But the point is, if they can delay adjudicating a case because there's a chance that they'll be striking down the statute as unconstitutional, Congress can come in and either rectify the statute by providing more detailed guidance in the statute, or by adopting the rules, right? Because if Congress adopts a rule that was promulgated by an agency in its statutes, there is no non-delegation doctrine, right? Where Congress gets its legislative text don't matter for purposes of Article 1. The question is, have they adopted some legislative text? Have they adopted the rule? And if they have, there is no longer a non-delegation doctrine. So delaying adjudication or delaying issuing the opinion could be useful, but they've also delayed the judgment or the mandate. That is to say, after they actually decide everything, they don't automatically necessarily have to have the mandate take effect. And so they could delay adjudicating the case, and they can delay the mandate. And the point of delay is to give Congress time to react either by modifying the statute and eliminating the delegation problem, or by ratifying the rules, that is to say, making the rules ordinary federal law, and thereby eliminating any non-delegation problem, at least going forward. So I think the courts have a role to play here. If they're going to be reviving the doctrine, they're going to be creating some uncertainty, but they can take measures that are designed to mitigate that uncertainty. Then when you think about the agencies have a role to play as well. They can delay the effective date of their rules, right? They can delay the effective date of their rules for prolonged periods of time, and they should be doing that where they think there's a chance that the rules result from a statute that delegates legislative power, or that arguably might delegate legislative power. What's the point of delaying the effective date of final rules, say for 180 days? It gives Congress time, again, to respond and possibly ratify those rules into law. And if that happens, it doesn't matter, again, that the rules were drafted by an agency and that they might have taken effect as law had the 180 days passed. So what I'm envisioning is, if an agency is deeply concerned that the statute under which it's promulgating rules has no doesn't satisfy the new non-delegation test that the court might promulgate, then the agency can just say, we're going to give Congress 180 days to respond to our rules, and hopefully, we're not sure it's going to violate this test, but if there's any chance, Congress can step in and ratify our rules. So the agencies themselves can protect themselves by giving Congress time to respond. And then the final thing that can happen is that Congress can actually do its job, right, rather than just shirking. And they can do it in two different respects. One, the non-delegation problem disappears as to all existing regulations that Congress ratifies into law, right? The CFR is full of regulations, some of which, or many of which, might be unconstitutional under a revived non-delegation doctrine. It is entirely permissible and appropriate, and indeed required, for Congress to ratify those rules into law, right? Especially the ones that would have a non-delegation problem. And if they do that, again, it doesn't matter that they were promulgated and they might have been unconstitutional for 10 years, because at least going forward, they're all going to be constitutional. So Congress can decide to ratify all existing rules on the books, or ratify most of the rules, but not all of the rules. The ones that it chooses not to make law, they will be subject to the court's non-delegation test. The ones that they decide to make law for either 6 months or a year or 2 years or however long they want to make them law, they're not going to be subject to the non-delegation test because Congress will have done its job. And that deals with the problem of all the existing regulations. What about ongoing regulations? Well, I think it's perfectly possible that Congress could decide on a biannual or annual basis to have a legislative vehicle that adopts all existing rules that have been promulgated in the last 6 months or a year. And that too would deal with the non-delegation problem, right? It wouldn't involve fixing the statute, but it would involve legislatively adopting the rules. And there are existing procedures in place for a budgetary process that doesn't always work well, but they typically do pass a budget, either an actual budget or some sort of continuing resolution, because there needs to be a federal budget for the government to function. And if people are really of the view that we need to have this level of regulation, I think Congress will respond. They'll have to respond, right, in the wake of a non-delegation doctrine to ratify some or all these rules. Now, I'm not minimizing the disruption. I think there will be disruption. And I don't mean to suggest that every existing rule on the books will be ratified by Congress, or that every new rule promulgated by an agency will be ratified by Congress. It's entirely appropriate for Congress to say, we don't want to legislatively adopt this rule. We don't like the rule. And if that's the case, then it'll just be subject to the non-delegation doctrine. That, to me, makes sense, right? Article 1, Section 7 is not a bug. It's a feature of the Constitution. And if an agency can't get its rule through Congress through one of these vehicles, it shouldn't be law. Or more precisely, it shouldn't be law if it doesn't satisfy the new non-delegation tests that the court promulgates. So I fully am aware that there'll be some transition issues, and I fully am aware that not all these rules will be able to make it through this process. And I'm also aware that Congress, isn't the smoothest functioning entity. But to the extent that there is a demand for legislative regulation, regulation of various sorts, I think Congress will have to respond. I don't think that the revival of the non-delegation doctrine will lead to no regulation of pharmaceuticals or consumer products or banking products, et cetera. I don't think that that's possible given the American public's appetite for those things. And so therefore, Congress will just have to accept responsibility, right? More responsibility than it is now. And I think that would be a welcome thing, and it's constitutionally required, right, that Congress take responsibility for these various things. So the point of my particular chapter is to deal with the transition issues. Many people have problems dealing with transitions. I'm sure we'll have some problems here, but they're not insurmountable. So thank you so much.
Thank you, Cy. So since we're a little over time, I thought we might turn directly to questions, if that's okay, unless any of you have a comment you want to make in response to each other's. Okay, I thought I would take advantage of Adam White being here. So Adam is very well suited to ask a question about this because at first he was a litigator of administrative law in Washington, D.C. at one of our prominent firms, and then with Boyd and Gray, and he is both a scholar here and a professor at George Mason Law School. So I thought, Adam, why don't you, I know you're bursting with questions, so why don't you go first? And I'll repeat the question for the audience. Yeah.
I'll just say briefly, since this is AEI, when Justice Scalia was a think tank scholar at AEI, he wrote a paper where he was a little wary of the non-delegation doctrine. It was probably of a piece with his wariness of the judicial activism that he saw prior to his era. So I wonder if the court were to adopt a new non-delegation doctrine, would it give rise to the sort of cast of mind among judges of sort of an activist mindset that Scalia worried about? And it made him so wary.
Yeah, so Adam's referring to Justice Scalia, his time here as a scholar at AEI, and his one of the leading administrative scholars of his day. He was quite reluctant, as many people have mentioned, about a vigorous non-delegation doctrine because of his counterbalancing concern about judicial activism. Do any of you share this concern about the courts becoming too active, maybe slipping into policy rather than sticking to law if they were to take up restored non-delegation doctrine?
Well,
Gary?
I mean, I think they have done that by not enforcing the non-delegation doctrine. It was rather obviously a choice driven by policy preferences of a number of justices. Justice Scalia was something of a special case on that. How shall I put this delicately? Justice Scalia was more driven by a theory of judicial role than he was by a theory of the Constitution. Or put another way, his theory of the Constitution was a product of his theory of judicial role. He was not an originalist first and an advocate of judicial restraint second. He was an advocate of originalism because he thought that best implemented his vision of judicial restraint. If there are judges who have that mindset, and there might actually be a few of those on the court, we don't know, we haven't heard from some of them, one of whom was a former Scalia clerk that we haven't heard from, yeah, I think they would probably share his suspicion or concern about any doctrine in this area, because unless one goes with David Schoenbrod's kind of approach, which I think has a lot to commend it. I just don't think as a practical matter you're going to get 5 justices to support it. Anything else that we can plausibly put forward is going to require judges to exercise judgment. There's no avoiding this. The common law test that I put forward, does it resolve all cases completely? No, that's why there's a body of doctrine from hundreds of years that I can fill up a chapter with, because there was stuff for judges to decide. I don't think Justice Gorsuch is going to be bothered by that. I don't think he minds judging, right, which is kind of what judges do. Justice Scalia was suspicious of judges judging. And again, given the era he grew up in, he had reason to be suspicious of it. He was a child of the Warren Court. But as a matter of actual how many people right now are going to be driven by that, fewer than would have been 30 or 40 years ago. I'm wearing my Federalist Society tie here, I think partly because of the influence of the Federalist Society. There are more judges who I would describe as constitutionalists rather than conservatives, people whose first priority is to get the Constitution right, and if that means that they do things that people in the 60s and 70s would have scoffed at as judicial activism, they'll shrug their shoulders and say, but look, read the thing, that's what I'm supposed to do. I think there's more of that now. Not 100%, but more of it. So long answer to a short question, but the long answer is, yeah, I think that's a legitimate concern, and it's an empirical question how much of an impact that's going to have on actual decisions.
Let me add
Gary speaks with some authority because he clerked for Justice Scalia twice, just wanted to point out.
Yeah.
which means Justice Scalia didn't believe in returning goods that he was no longer happy with. And I should also mention, I forgot in your introduction,
He liked to argue.
he never went to Costco. And Gary was also the Associate Dean for Intellectual Life at Boston University Law School, which seems like an impossible task. Go ahead,
Yeah,
Todd.
if I could just add 2 points. First of all, you're talking about Scalia young, early in his career, young Scalia. We pointed out in our chapter that sage, wise Justice Scalia was beginning to admit change and admit some mistakes. And, he did that in Chevron. He did that in embracing things like the major question doctrine. But I think we pointed out in Michigan versus EPA was another question where it wasn't a non-delegation case, but he was pointing out that Congress really needs to make these decisions and expressing increasing concern over the undemocratic accountability of the regulatory agency. So we actually argue that the more mature Scalia would have realized that his void for vagueness opinions were right and would have either embraced or at least not had a problem. And I think that's probably true for other judges, like Gary said.
Si? Yeah.
I mean, Justice Scalia famously wrote that article, "The rule of law is a law of rules," and he didn't write the rule of law as a law of standards. And a lot of the tests here are standards, not rules. But I think David's test is a rule, and I think you could understand some of the test as carving out certain categories as having a rule-like feature for saying that these things can't be delegated. And then, of course, Mistretta, right? He says that you can't create a junior varsity Congress. That's a rule too, right? It's easily administrable. Does the Constitution only establish rules? I share Gary's intuition. The answer is no. I don't think everything in the Constitution is reducible to a rule, at least as a matter of interpretation. But as a matter of implementation, you could decide that even if it might enact a standard that we want to adopt a rule, or that we can't we can't write a test that just mimics what we think is implicit in the constitutional text, and we will implement it, maybe under-enforce it by adopting a rule, recognizing that it's not fully enforceable. So I think it's possible to meet. I mean, certainly Scalia thought he was doing something in Mistretta when he said you can't create a junior varsity, and he thought he was enforcing the non-delegation doctrine in that case.
Let me take a question from the audience, from the online audience, and then I'll come to Mark. So this is a question about the Federal Reserve, but I think it opens a broader question. So the question is the power of the Federal Reserve to try to control contradictory objectives of low inflation and low unemployment a form of delegation of unrestricted authority? But maybe it opens a broader question. What happens when delegations are in conflict with each other? Does that open up even more avenue for the judiciary to maybe be activist, as it were, in enforcing a kind of non-delegation doctrine? So,
well, since my chapter actually talks about the Federal Reserve specifically and the power to coin money and regulate the value thereof, I'll give my answer. I think it is without reference to the fact that there are conflicting standards specified using the earlier notion from Mark and Richard of the core legislative powers, if you will. It's perfectly obvious that Congress is supposed to regulate the value thereof, not designate someone else to regulate the value thereof. I think that's an easy case under my kind of common law background approach. Be flagrantly. What Congress could subdelegate is who actually stamps out the coins in the mint. The members of Congress don't have to go actually into the mint and stamp the coins, but regulating the value thereof, I think there's zero case, regardless of the standards that they specify. Now, what I then go on to say is that, as Robert Bork said, is the sort of thing that gets you a guardianship when you try to frame it into the real world. It's entirely possible. That's what he said. Someone who said the Federal Reserve is unconstitutional would not need a law clerk, would need a guardian. That was a Bork line. So I think there's zero chance that you're going to see 80 Supreme Court decisions saying, oh, by the way, that Federal Reserve Board, unconstitutional. But the question is, why would they say that? Not necessarily because, well, the Constitution permits that, but it's been around for 100 years. And there are all sorts of contexts where that's, at least in the legal world, a conversation stopper. There are certain things, no matter how wrong they are, no matter how clearly you can point out that they're wrong, nobody's going to change them, and I think that's one of them. But I don't think it's a question of the conflicting standards. Now, the conflicting standards question is a valid one because there's a whole ton of statutes that I call them goodness and niceness statutes that just sort of give a whole list of goals. If you look at the list from the National Industrial Recovery Act from 1935, it's a perfect example. Increase employment, promote production except when production would be excessive, and conserve natural resources, and make sure the Seahawks have a good offensive line next year, and sort of anything that you could come up with that sounds good, we'll throw that in there. Yeah, those are entirely problematic. What David might call goals statutes run riot. But I think there may be contexts, depending on the function, when that might actually be okay, depending upon whether you're dealing with the sort of thing that traditionally would have been part of of course, somebody else can do that. You don't even have to give them a standard. You let them figure out how to get the document filed. You don't have to tell them, what carriage company to take to file the document. Just get the document filed. We don't care how you do it.
I got something to say. The Bork comment is funny, but I think, if you were going to go back 30 years or 40 years and you ask, well, are they going to, modify the Commerce Clause doctrine? I think a lot of people would have said, well, you need to check into the funny house if you think they're going to do that. And the very fact that we're having this conversation today, I think suggests, because I don't think that people would have foreseen a possible revival of the non-delegation doctrine 20 or 30 years ago. Certain people wanted it to happen, right? You and David, but I think what's plausible changes over time, and I don't know if it's the case that Judge Bork's remarks still hold true today for the Federal Reserve.
Let me just say, 1 year before Lopez, in 1994, a law professor wrote in a law review article that asking for the resumption of the doctrine of enumerated powers was like waiting for the redemption of imperial Chinese bonds.
Well, we're going to have to make the Chinese pay for COVID one way or another.
Yeah,
Great timing on my part there. Huh?
I'll just explain my dodge and my further support for multiple standards, theories, rules. If I wasn't clear, we think certainly our standard, the word for vagueness, maps almost perfectly to coercive regulations that regulate private conduct, whether it be criminal or civil. And outside that, I think there are arguments for other tests. So that's when I would dodge to Mark and Rich or Gary. But I don't understand, and my second dodge is I don't understand what the Federal Reserve does these days, if I ever did. But maybe the regulation of the money supply. I don't think it directly, coercively, it steals from me, but indirectly. It doesn't directly order me to do anything. So I think that's an example where the court would say, okay, a different standard or a different test might be appropriate. In shared, it's even more clear in the shared power context. It's not the question you asked, but one of the hypotheticals is, if Congress were to pass a law saying the president could meet and treat with any ambassador to negotiate any treaty he wants, that is very, very open-ended. That is a junior varsity kind of Congress, except the president already has that power. So since the president already has that power in Article 2, it doesn't present a separation of powers problem. It is Congress maybe giving whatever its foreign policy imprimatur, and it would be a silly law. But then there are going to be cases that are a little closer that might regulate the military. And since the Congress clearly does have some role and the president has some role, I wouldn't apply the same standard when Congress is regulating the militia because the president has independent authority.
Good. So Mark, before you ask your question, we're a little over time, but since I'm doing the conclusion, I'm just going to make my conclusion really short. So let's have like 10 more minutes of question time. Extra points if you can mention another AEI constitutional law scholar in addition to Bork and Scalia. There's only 2 left, but I bet you're not going to. So I'll mention Walter Burns and Bob Goodwin. But anyway, go ahead.
You took the one I had in mind. So void for vagueness is a problem with vagueness at the point of enforcement, typically. But the problem with non-delegation is typically not a problem at the point of enforcement. That is, the agency is often crystal clear about the scope of the prohibition that it wants to put into place. So the question is whether Congress authorized the agency to specify or expand the statutory prohibition in that course or fashion in the first place. So my question for Todd is, how does the void for vagueness doctrine answer the question whether a gap in the statute is a detail for the agency to fill or just a place where Congress decided to stop legislating?
Yeah, the again, more modern statutes do say it's not enough if a judicial decision supplies the clarity. So the clarity isn't enough, or that the agency through rulemaking does enough. But the basic question is, has the legislature provided enough detail for the enforcer? And this is where I think there's a large overlap with your and Rich's test. Has it provided enough detail that they're limited in their way, that they're actually engaging in an act of enforcement? And I think that both part of your theory and part of expanding upon the void for vagueness doctrine would require the courts to think a little bit more about defining what is interstitial lawmaking, interstitial rulemaking, what is inherent, unavoidable enforcement discretion, and what is, and I wouldn't say in this, for this subject matter, one of the thoughts I had in some of the environmental laws, Clean Air Act, and I probably forgotten at least most of what I used to know about that, but I was talking to someone just this morning. They actually set out some ambient standards on, so they had hearings after hearings after hearings, and then they delegated certain authority to the agencies to carry on. But other statutes, they just punted to the agency to begin with, and they didn't come up with any standards. Well, at least within the Clean Air Act, you knew that certain types of pollutants, certain types of and I should, David can probably teach us chapter and verse on this, but I'd be interested later on over a drink, we'll ask him, why did Congress feel either competent or willing to specify certain things in the early 1970s that it does it today? I know that's not a great, I don't think that's a great answer. It might not even be a good answer. Maybe someone else can answer the question better. But the movie censor ordinance is a pretty good example. There, the legislative entity was really trying to create a junior varsity movie censor, and they were going to actually deliberate, and they were going to make these decisions, and then theaters would know whether they could show the problem. The Supreme Court said with that was that it wasn't clear by the statute itself. It is not enough to assign that to somebody else.
Maybe Todd was inviting the other 2 panelists, but maybe the question could be, what does your vision of the non-delegation doctrine do with statutory silence, right, which is a little different than what you usually confront with the void for vagueness problem. But for example, in looking at the 18th century common law principles of agency, how do you handle just flat statutory silence?
You look for background understandings and norms the same way you would with a contract of agency. The contract is never going to specify everything that constitutes what the agent is supposed to do or not to do. It's going to set out certain functions. There are going to be other functions that are, this is the common law term for it, incidental to those functions, that just flow as a matter of practice, understanding, and parlance from the specification of those functions. And there are going to be certain other things that you look at and you say, what? The sub-agent was told to do what? I don't think statutory silence is all that different. It's going to be silence in the face of something the statute said. You have a statute or you don't have statutory silence. The statute's going to say something. It's going to commit some element of power to this executive agent. It is, I don't think, the case that the grant of power is always exhausted simply by the semantic meaning of the words written in the statute. That's not how communication works. Communication involves background rules, understandings, presumptions, defaults. That's what ordinary interpretation is. I mean, am I wrong about this?
No, you're always right, Gary.
No, I'm not.
No,
I was wrong in 1994 about whether we were ever going to see enumerated powers.
He means to say you're wrong about a lot of stuff, just not this point.
Okay.
I mean, I want to say something about Todd's test. I really like it because it takes an existing test that people are already committed to, both conservatives and progressives. And so now no one can say, oh, this test is too vague because they're already doing it, or it's problematic. They're already doing it. And so it's impossible to say, well, this is now problematic because we're doing it elsewhere. Now, it could lead to a situation where they find fewer things void for vague, right? Because they're worried about how it's going to apply in the other context. But it's sort of a jujitsu move, right? To take some doctrine that progressives are committed to and then use it in another area. And then to say, you can't have a problem with this because you're already doing it. So I commend you for thinking of it.
Great. Well, we only have a few minutes left, so let me just make some concluding remarks so we can end on time. First, I just want to point out that this is part of a project of the broader work on constitutional studies that we do at AEI. Peter Wallison is part of that. Adam White, who's here, is part of that. People have mentioned many of the other people. Judge Bork was here for many years. He was a part of that. Justice Scalia, part of that. I want to thank the head of that program right now, Yuval Levin, who was very excited to hear about this project, authorized it, and has supported it throughout. And then again, Nicole and Sophie, who are here. I also forgot to mention Sarah Bowe, who's the one who's brought the book through the editing process. Let me also thank in particular Peter, who he didn't introduce himself. He had one of the most important jobs at one of the most important times in our history. He was counsel to the president under President Reagan in the second term. Before that, he was a general counsel of the Treasury Department. And I think combined interest in constitutional law with, the only person I really trust about banking law, frankly. I don't understand banking law, but when I have a question, I look at Peter's writings for the answer. And also, let me say, Peter, it was really good to work with him. He's a tough editor, and he really shows the difference between the academic view and the think tank scholar view. Because the academic view, in all of your articles, there would be things that you would go off on, we all do, right? Go off on tangents, unnecessary footnotes, and I'd be like, that's really interesting. Peter would say, cut it out. And he would say, why cut it? Because Peter would single-focused on answer the question, what is the test? And so I'd be like, let them all say whatever they want. And Peter say, no, what is a test? So I don't know if Peter's going to appreciate this, but in my mind, I considered him Cato the Elder, which makes me, I guess, Cato the Younger. You may remember Cato the Elder is known for saying over and over again in the Roman Senate, Carthago delenda est, Carthage must be destroyed. This is Peter's attitude towards the administrative state. So this is how I remember my art, because we spent much time virtually and together editing this book. That's right at the end, right. But Peter, it was wonderful because he kept us single-mindedly on the goal. Answer the test. And let me just finish by saying, I think this is an extraordinary contribution, this book. I didn't contribute a substantive chapter. But think about it. For those of us who teach administrative law, we love teaching the non-delegation doctrine as an example of, we know there's a principle that most of us agree with, but the courts cannot figure out the test, so they just don't take any cases on it. Right? That's sort of I would say that's how most administrative law professors probably teach the non-delegation doctrine. I think this example where a think tank, rather than a law school, brought people together and just said, figure out a test. As Gary was saying, figure out the test. Don't think about the theories. Don't think about whether the test matches up exactly with your theory. Just figure out a test that advances the constitutional principles that courts can advance. I gotta say it's remarkable that you have a book, and I hope law students and professors will look at it as well as judges. Here is a book that offers several tests, not just one test, but several tests to a question that even the great Justice Scalia thought had no answer that judges could enforce. I think that's a very important contribution. I think it's something that actually AEI we could do more of. Let me just briefly, just in my concluding remarks, just explain my concluding chapter in just the short time we have left. I'm sure Cy didn't read my conclusion. I'm 100% certain Cy didn't read my conclusion. This is what happens when you sit in an office for a year together. You have Vulcan mind meld. Because your comments were exactly my conclusion, Cy. Did you realize that? No, you did not. So, as a law professor, you never ask questions you don't know the answer to. My chapter is just about rules versus standards. Actually, how do you pick, when you have a number of rules, how do you pick the best one? And so I pointed out, as Cy did, that some of our authors picked rules, some of our authors picked standards. A rule, right, is a very clear rule. Standards are often balancing tests, and neither of them are right or wrong. They have different features. Standards have high decision costs because you have to balance all the factors. Rules have low decision costs because you just say, if you're driving 55 or faster or lower, you're in compliance. If you drive 56 or higher, you're in violation. One other thing that standards and rules do is that they are about transferring power. If you think about it, a standard gives the power to the present decision maker, the judge or police officer of today. The rules look backwards in time to the lawmaker and privilege their power. And so just Gary's view would be to privilege the decisions made by the founders. Right? That's what his rule would do of the 18th century principal agent. Some of the others today would privilege the decisions of decision makers now. Right? And that's an important distinction. And I think, as several of you point out, Justice Scalia himself might have been somewhat at odds with himself on these questions between the commitment to originalism, but also his commitment to, his commitment to defending most of the major pillars of the modern administrative state. And I think that's one way to think about all the chapters when you read them, is where do they fall in the standards and rules question. And then my last bit that I make the pitch for in the conclusion as bring it to a close is, if you're a court, and Todd alluded to this, if you're a court and you're going to take the very first step to enforce a non-delegation doctrine, there's going to be a lot of potential political controversy and criticism. That's the kind of circumstance I think a court, it would be particularly well advised to use a standard. And then the standard generates more information for you about what you're doing. And then over time, it can become a rule. And that might be something that the justices, when they handle the two cases that are coming before them this spring, might consider. Well, again, I want to thank everybody very much for listening in on the internet, and for those who came to present their chapters and for participating with us in this great project. And I also finally thank Edward and Helen Hintz for sponsoring this book forum and for commitment to the mission of AEI. So thank you very much, and the proceedings are closed.